Good afternoon, everyone. I'm
Good
Shweta
afternoon.
Bharti, and I'm good afternoon.
Good afternoon.
So
to all of you.
let me introduce myself. Good afternoon. Good afternoon, everyone. I am Shweta Bharti, and I'm the senior partner at Hammurabi and Solomon Partners and have over 2 decades of experience on the dispute and insolvency matters. And I have with me 2 undisputed, illustrious experts of the Insolvency and Bankruptcy Code, whose in-depth understanding of IBC will probably help understand the subject a little better for all of us. So allow me to introduce to the audience both the esteemed speakers who actually need no introduction. Honorable Justice S.J. Mukhopadhaya is the judge of the Honorable Supreme Court of India, retired, and has also been the ex-chairperson of NCLAT. In fact, sir was appointed as the first chairperson of NCLAT on 1st June 2016. And in his capacity as the chairperson, he has delivered judgments which, in fact, have explained the different provisions of the newly enacted IBC, on which there were no precedents, including the famous case of reverse insolvency, where, in fact, I had the privilege to assist in the matter as a lawyer representing the appellants. We also have with us Dr. M.S. Sahoo, who is the retired chairperson of IBBI, and who shaped IBBI to what it is with his passion and involvement. Dr. Sahoo is an acclaimed thought leader in financial markets, and in fact, he has also served as the first chairperson of IBBI. In his lifetime, in his time as the chairperson, the IBBI adopted several best governance practices on its journey to the institutional legitimacy that we see. And during this period, the IBBI had deep engagement with the stakeholders, and it made insolvency reform a journey by the stakeholders, for the stakeholders, and of the stakeholders. So just as a housekeeping rule, if there are any questions that you may wish to ask, please place them on the chat box and we'll keep taking them one by one. And with both speakers who had an instrumental role in shaping IBC what it is today, it would be interesting, in fact, to hear their views on some of the leaps that IBC has taken since its promulgation. In fact, we have also seen various amendments which have been made to the code, as well as the rules and regulations from time to time, which were made in order to iron out the creases, which were noticed during the interpretation of some of the provisions of IBC. In fact, if you look at the judgments, the way it has transcended Innovative Judgment, Mobilox Judgment, Chitra Sharma Judgment, Pioneer Urban Judgment, ArcelorMittal Judgment, K. Shashidhar Judgment, or even Swiss Ribbons case, you will see that all of them had an impact with respect to the amendments which had come in thereafter in the IBC. And the 2 recent, in fact, judgments which have also found its place in the amendments which were suggested on 18th January 2023 are the Vidarbha judgment and the Rainbow Papers. So it definitely is a very proactive step by the government to clarify the gray areas, and which were noticed pursuant to the judgments which were being passed by the Honorable Supreme Court, as well as NCLAT and NCLT. But even after all the proactive steps by the Government of India, when I look at the data which was released by IBBI in December of 2022, it in fact revealed that about 6,199 CIRPs had commenced, and of which about 4,199 had been closed. Of the CIRPs which were closed, the corporate debtor was rescued in about 2298 cases, of which 894 have been closed on appeal or has been settled. 793 cases have been withdrawn. 611 cases have ended in approval of resolution plans, while 1,901 cases have ended in liquidation. So, Dr. Sahoo, I will start with you first. Even after 8 years of IBC, we see that there are more liquidation as opposed to the successful resolution and revival. So what, according to you, is the underlying reasons or determinable factors for this? And how has IBC helped India in terms of ease of doing business? These are 2 questions that probably I thought I'll ask you first before we get on with asking Justice Mukhopadhaya with the other questions.
Thank you so much. Let me start with the very basics. This is a law. that endeavors to address stress of a person. And in the long title, it writes that this is a law for a reorganization or insolvency resolution of company, liability, partnership, etc., etc. So its sole objective is reorganization. And if you reorganize, several benefits accrue, like the promotion of entrepreneurship, availability of credit, or maximization of value of the assets of the corporate debtor. So the right question actually is, the code, in fact, the code provides for reorganization in two ways. First, by rescue of the company through a resolution plan, failing which by closure of the company through liquidation. It enables the market to make the choice, and market usually chooses to rescue a company if its business is viable or close it if it is unviable. So the law really does not distinguish or does not consider that liquidation is something bad. Liquidation is also one of the ways of a resolution of stress. Unfortunately, many people believe that rescuing a company, reviving company is only resolution. Actually, that is resolution by a resolution plan. There can be resolution by liquidation. What we are talking about resolution is that the business is not doing well today for whatever reason, internal, external, competition, innovation, technology. Is there any way can we put the assets, resources of the company to better use? Is there anyone else who can put in better use? If not, can we release the assets, entrepreneur, or alternate uses? So both resolution plan and liquidation, both are the two means of resolving stress, and one should not feel bothered at all if a company is getting into liquidation. By getting into liquidation, actually you are releasing the resources stock up in Chakravyuh for alternate uses. Second, look at the data. Data is quite deceptive. Possibly 2,000 companies have moved on to liquidation. But the companies which have not moved into liquidation are probably 100 times, 1,000 times of the companies that moved into liquidation. You know, you get the data, same in the IBB newsletter, it says that there were about 25,000 applications filed but withdrawn before their admission, involving an amount of 7 lakh crore. So these are the 25,000 cases we have data for which applications were filed but not admitted. Also, we have withdrawal after admission, but we do not have data about how many were resolved after getting the notice from a personal creditor till filing of application, or even before issue of the notice by an personal creditor. So those data we do not have, but those are actually resolution. Though their companies continue to exist, the stress is resolved. So that number is actually in the lakhs as compared to only 2,000. What you are seeing is that there are people come to a hospital, people get relief at OPD, people get relief by preventive medicine, OPD medicines, people get relief from indoor treatment, and some people go to a critical treatment stage which they complete the finishing line. Of them, some survive, some pass away. So you are only looking at a very small subset and then saying that, see, in this subset, these many are getting liquidated. Further, the number of companies appear to be high, but look at what is material is how much of assets they have. We see that the number of companies which have been rescued, maybe 500-600 companies, they account for 3/4 of the distressed assets. The companies which have moved to liquidation, they account for about 1/4 of stressed assets. So if you look at a value, companies rescued are actually 3/4. Number is deceptive. And still more important to know is that who are getting into liquidation? 3/4 of those companies were either sick or defunct to start with. And even the companies which have been rescued, 1/3 of them were either sick or defunct. And the ones which are getting reserved or rescued, you look at the data to start with. We find that the 600 companies which have been rescued, to start with, they had assets valued only at 17% of the claims against them. The companies which are getting liquidated, they had assets to start with at the time of a CIRP, about 7% of the claim of the assets. So who are getting liquidated? Quite often we have heard of, you might have heard of Khatironga Minerals and those companies which owed 8,000 crore to banking system, and banks got only zero amount out of this. This became a big news in newspapers. And it was that the company never existed actually, even when it came for a ritual, for a kind of a cremation. There's nothing left with the company. So NCLAT right away, what to speak of admission, along with the admission, it passed the order for liquidation and also dissolved the company. So if you come with zero asset, it's like a patient coming to hospital, at what stage it is coming. If the company has remained sick for years and then comes to hospital, you don't expect the company to be rescued. As regards the ease of doing business, I think we have pakka data. The improvement of India's rank in World Bank's resolving insolvency parameter over 3 years, because we have data for 3 years. We do not have data for last 2 years because the World Bank has discontinued that following some problem. But we find that over the past 3 years of operation of IBC, the ease of doing business ranking of India improved from 136th position to 52nd position. That is quite remarkable. And further, if you drill down, the overall recovery rate for creditors jumped from 26% to 72%. World Bank says that recovery is 72%. We have problem with our data, which shows 30%, 35%, 40% recovery. If I get a chance, I'll clarify that. But World Bank takes that our recovery is 72%, 72 cents on dollar. And time taken for resolving insolvency has significantly come down from 4.3 years to 1.66 years. Cost of transactions has come down to 9.6% to about 1.5%. And India is now by far the best performer in South Asia on the resolving insolving component, and does better, much better than the average for OECD high-income countries in terms of a recovery rate, time taken, cost of CIRP. And if you recall, the performance of the Indian insolvency ecosystem that earned due recognition, India won the prestigious Global Restructuring Review Award for the most improved jurisdiction in the year 2018. And from providing freedom of exit to rescuing companies in financial stress, to releasing entrepreneurs and idle resources stuck up in inefficient uses, to helping creditors realizing their dues, and most importantly, bringing about a behavioral change among the debtors and creditors alike. I think the list of achievements of the code is in fact a long one. Thank you.
Justice Mukhopadhaya, sir, would you want to add on anything to this comment of Dr. Sahoo?
See, I'll be only adding one thing. How many companies have been liquidated?
Sir.
You see, corporate debtor survives either way. Mr. Sahoo has given OPD and those who have been admitted. How many are dead? There is no data. So liquidated may not be such, it may not be 1%, it may not be 2%. So main thing is company is surviving. Now rescue, you are talking of haircut in your question number 1.
That's my question, next question.
And
yes.
in one case, I ask a person, if a person is a bald, then 2% is a hair plantation, not haircut. If it is complete bald, then there should be another word, hair plantation. So third party, if it provides 2% or 1% or even 6%, that is not the haircut, it was the bald. And therefore, Mr. Sahoo was telling very candidly
Yes.
That in the very beginning, where there is no asset, nothing is there, that has been ordered to be liquidated. But they do not actually not liquidated. Somebody has planted the hair and taken out. So it may be 2%, 3% planted. So I'll be saying, change your mindset. No haircut, but sometime hair plantation is the modern day. That's I want to add.
Right. So I'll in fact come to this question itself, because we in fact are seeing that, the revival is being done. And I completely agree to that. But then revival at what cost? Because if we look at the present scenario, even large conglomerates with valuable assets are attracting bids which are far below the liquidation value. And in growing number of cases, we have seen that the creditors are happy to accept a haircut of about 80 to 90%, leaving almost nothing for the other stakeholders. So in such a circumstance, are massive haircuts impacting the purpose and objective for which IBC was introduced in the first place? That is a question, Dr. Sahoo, for you.
Okay, I think Justice Sir has explained quite a bit of this question.
Yes, yes.
So, I don't believe that there is a company which has a value and there are no takers.
Yeah.
In Indian market, we have seen so many IPOs who are saying that we will never make profit in our life. We have accumulated loss of thousands of crores, yet there are people who are dying to give money there. So that means there's some problem with us when we say that there is a value, there are no takers. Okay, let me come to the very basics first. It's axiomatic that if a company is coming to IBC, it does not have adequate assets to fully repay all its creditors. And I gave you the data that when a company is coming to IBC, and those which have been rescued, I'm not forgetting about liquidation, the ones which have been rescued, to start with, they had 17% of the amount due to creditors. The assets available with them, the liquidation value of that was only 17% of the claims due. That means the process was starting. When the process started, creditors were staring at a haircut of 83% to start with. And again, as I mentioned, 1/3 of these were defunct. IBC not only rescued this company, but reduced the haircut to about 65%. People are getting 35%. But when they started, the haircut was 83%. And there are some transplantation of hairs. That's why the haircut reduced from 83% to 70% or 65%. And I gave you the examples of the companies like Getoranga. Now, look at how these numbers are getting calculated. Why does World Bank say that the recovery is 72% and why do we say 35%?
Yes.
It is something to do with the way we look at it.
Yeah.
Quite often, like my earlier question, I told that people do not consider liquidation as a resolution.
Yeah.
People do not understand what is haircut.
Yeah.
See, haircut is that what you are doing is, it is typically how you calculate with a numerator upon the denominator. So
Correct.
total claims minus the amount realized. So the amount realized by the amount of claims. So the numerator is the amount realized and denominator is the amount of claims. But the amount of realization, the way we calculate, does not include the amount that is realized from equity holding post-resolution, does not include realization that is getting realized through reversal of avoidance transactions, does not include the amount that would be realized through insolvency resolution of personal guarantors and corporate guarantors.
Correct.
And the amount is so much inflated, it includes NPA, which is already written up in the books of the bank. It includes interest, penal interest. In the denominator side, you know the famous case, where the NCLAT made a statement that a 95% haircut is the video call. The amount of a claim was about say 65, 70,000 crore. That included a loan amount of 25,000 crore, included a guarantee amount of 25,000 crore. It is only one loan One has given guarantee, one has taken the loan. So you count it twice. So the denominator gets inflated, numerator gets deflated. That is why our figures are deceptive as compared to World Bank figures. So it is not that much haircut as we believe. Then you have to see the haircut in relation to the assets available on the ground, not the claims of creditors. Because market is not going to offer a value in relation to what it owes to creditors. It offers a value to what a company brings on the table. IBC can maximize the value of the assets at the commencement of the process and not the assets which did not exist when the process started. And because the IBC is able to do some hair transplantation, the going concern, we are able to realize some going concern surplus. Rescue process is realizing on average about 178% of the liquidation value of the existing assets. Therefore, we are getting 78% bonus instead of haircut. We have many companies where realization is 100%, more than 100%. So why do you think that some companies we are getting 100% realization, more than 100% realization, and why in another case 100% haircut? Is it because of IBC or RP or NCLT or something else? So you have to see, just asking this question, why in 50 companies, IBC process with the same NCLT, same RP, same COC are realizing 100%. Why in the other 50 cases, they are losing entire 100%? So that means problem is not with the IBC, which is something else, but we find something wrong with somewhere else. I think I will stop it here, leave it for Honorable Sir, Justice Sir, if you would like to add something.
I just want to add one thing.
Yes, sir.
You see, we are looking always towards the past. Right. We are not in future.
Yeah.
A company survives either way. Yeah. Haircut, hair, implantation or no implantation. Yeah. After taking over by the third party, it generates employment. Yeah. It is eligible to take loan. Banks are ready to give them loan. Again, those who are financial creditors, operational creditors, they are again ready to supply goods on credit. So whatever the blood supply stopped, the circulation of blood starts, a new blood is infused. So generation of employment is a benefit.
Right.
Generation of, again, this loan taking and giving system is a benefit. Operational creditors are operational, those who are supplying goods, again supplying goods, who stop supplying to the new one after survival by any means. And government will also generate money by way of GST, income tax, other tax, etc. So post-survival benefit should be notionally calculated. It's not the past, whatever the claim filed up to the date of admission is not the factor. Post-benefit is one of the factors to be taken into consideration for the purpose of calculating the total benefit. It's not a revival of a company. It's a keep it a going concern. And that is, I think that should be also looked, and some research should be there thereafter, that how many companies are doing good and how many funds they are generating.
Right. So one of the cases, sir, of Shiva Industries and Holdings, in fact, that matter went from NCLT, NCLAT, and then up to Supreme Court. NCLT had rejected the OTS and the withdrawal under Section 12A of IBC and had observed that it was not in conformity generally with the principles of IBC. And because 9 lenders had accepted the settlement and agreed to receive about 328 odd acres against the admitted claims of 4,863 acres. So subsequently, NCLAT had also allowed the decision of the NCLT, but it was ultimately when it reached up to Supreme Court that Supreme Court overruled the decision of NCLAT on the principle that the commercial wisdom of the COC, it is the cornerstone of IBC, as was also held in the case of Arun Kumar Jagatramka versus Jindal Steel, and that the need for judicial intervention or innovation from NCLT or NCLAT should be kept at its bare minimum and should not disturb basically the foundational principles of IBC. Now, with that kind of an understanding, are we giving too much power to the COC and leaving only for the COC to decide on the fate of the company? And would it be correct to say that one of the major contributors to escalating haircuts is also the one-time settlement through withdrawal of insolvency, which is done by way of Section 12A of IBC? I just wanted your thoughts, sir, on that, Justice Mukhopadhaya.
I can start with one of the practical cases.
So,
one of the case, liquidation value was more than 500 crores. There was approximately 600 and odd crore. The liquidation stage, the offer was 477 crore. NCLAT said that it cannot be less than the liquidation value. And then this judgment was reversed by Honorable Supreme Court during my time. Supreme Court says it is not your look down that how much should be taken. That is the committee of gator under subsection 4 of section 30. NCLT or NCLAT has not been empowered to look into the commercial wisdom. Then I demitted the office. After demitting the office and looking into various cases where I was giving opinion or something else, then I thought one day that why this type of thought process was there by Honorable Supreme Court. Less value.
right.
Now, if you have a furniture in your house,
Yes.
now you want to sell it, cost may be X. If you want to sell it for a little value, then who can stop you?
Right.
Because you want to get the money. If you get less amount for that sale, can you never come and say that why you are selling for a less price? Can the law say why you are selling for a low price? That sell, if you get a less one, may be profitable to you because that may give you more space to do business. So I thought that Supreme Court was correct in saying it is not our lick down because money is to go to the COC. COC will decide how much they will take. Where is the question of comment from the other party? That why you are taking less? We are looking into the pocket of the COC, that why they are charging less.
Yes. Yeah, very eloquently put. Thank you so much, sir. Dr. Sahoo, do you want to add something to this?
Yeah, you referred that 29A applicability, you referred in Arun Jagatramka case, Gujarat Court, where Supreme Court told that the tribunals, they should not be innovative, they should keep to the minimum.
Yes.
Yes, they should keep to the minimum, that is perfectly fine, they will keep, that means there should be commercial wisdom should have a priority.
Correct.
Whose money we are talking about?
Okay.
First is, let us forget that IBC is not a cell. IBC's focus is resolution of the company. Company should continue to exist. Thereafter, can we get something?
Right.
And it is their money, they are taking a call. They are taking a call with a 90% approval of the majority.
Yeah.
So where is the question of the court, judiciary, society coming and telling them that, no, don't do anything with your money?
Yeah.
What are they doing? They are simply saying that, let us go back to the original position, as if the process had not started. If the process goes through, the committee of creditors write up the dues of operational creditors and of government, so many, or the decisions become binding on everybody. So those kinds of drastic things which the committee of creditors does through a review process or the NCLAT approval brings in, those benefits are not available to the company where approval is, where the process is undone or we go back to the process.
Okay.
So only when the company changes hands, company's assets are sold in the liquidation in bits and pieces, or company goes back through that case of Gujarat Nehari Coke, where Jagtarmaka wanted to get back the company. When the company goes back to the person who is 29A ineligible, then the question arises. That means where the IBC process is run, there 29A ineligible person cannot
participate.
But if the process is not run, you are going back to the original position.
Yeah.
That is as good as the process had not started. If the process has not started, can government or NCLT go to that company and say that you people have become ineligible by virtue of 29A, therefore you give up your company? So Supreme Court is right, and as Justice Mukhopadhaya elaborated with that very nice example, that it is not the lookout of the state court, anybody to see. If we are admitting that it is their money and they are taking commercial call, we can't be saying that you can't decide this way or that way.
Correct.
That's not fair.
Yeah. In fact, in this line, there is a question which is there in the chat box, and I think I'll just take it up because we are talking about 29A. So the question says, how far it is fair for a resolution applicant to invest in an ARC and then make the ARC to initiate CIRP and then control COC and get the plan approved? How is it different from Section 29A? This is the question by Mr. Rajiv Chaube. He is the General Counsel at the moment for Dalmia. So this is a question from him. So either of you, whoever would want to take it up, sir, this it's a very interesting question that has been asked. Would it be fair for a resolution applicant to first invest in an ARC and then that ARC initiates the CRP and then get control of COC and then get the plan approved? So what cannot be done directly cannot be done indirectly as well, is what my understanding is.
So you are presuming that the rest of the market is dumb. They don't understand anything is happening. Only this person sees the value. The rest of the world can't see the value in the product. Nobody can give a competing plan, better plan. So I don't subscribe to this at all, actually.
Correct.
What you are essentially saying is that whether a member of the committee of creditors can be a resolution applicant.
Yeah, in this
question.
Yes.
So where is the conflict of interest?
Yeah.
I don't see any conflict of interest. Sir, you would like to
add something to this, sir?
Actually, there is the outlook.
Yeah.
You have gone to 29A first.
Yes.
You have not gone to financial creditor first. Whether a financial creditor is ineligible because of 29A.
There is no such
so if he is a financial creditor, and he is not barred otherwise, then he will be coming in the committee of creditors. So if he can be member of a committee creditor, then where is the question of attraction of 29A for the purpose of resolution plan? If he is a related party, this party, that party, then he can't be a member of the committee of creditors. So both things can't go together.
Right.
Because the moment I say he is a member of the committee of creditors, that means he do not come within the meaning of 29A.
Correct.
Not a related party, etc.
Of course. Correct. Right. So taking the discussion forward, sir, and prior to, in fact, innovative judgment, there were uncertainty surrounding the factors with respect to NCLT, whether they should consider when assessing an application under Section 7 of the IBC, the common defenses which were used by the corporate debtor. And in fact, it also included the claim that the default was, unintended, brought on by events outside their control, or that they were otherwise, financially solvent. So I think the Supreme Court had laid down a dual objective test of debt and default, and that was established in the judgment of innovative, which helped and resolved to streamline the Section 7 application adjudication process, and it brought an end to this ambiguity. And thereafter, in the changes which we have seen in the judgment of Vidarbha of 12th July 22, where the court decided that despite the court being convinced of the existence of a debt, and the corporate debtor being in default, Section 7(5)(a) of IBC given the NCLT discretion to refuse to admit an application for CIRP, which was submitted by the financial creditor. And it contrasted and contrastingly noted that even if an application for CIRP is submitted by an OC and it satisfies the same condition of debt and default, the NCLT has to mandatorily admit the application. In fact, the court had pointed out a very interesting aspect that the word may is directory and the phrase may admit gives admission a discretion. However, the term shall implies a rule that it must have to be followed. So the court assumed the legislation's intentions by stating that the use of the word may in Section 7(5)(a), it is in contrast to the use of the word shall, which is there in Section 9(5)(i) by the legislature, which meant to imply the discretionary powers were intended to be given to the court in matters of 7(5)(a). Now, this is an understanding which is there with respect to the law as it exists today and the interpretation of the judgment as has been given in Vidarbha. Now, with this ruling of the Supreme Court, there is one issue that arises for consideration is that should law have room for subjectivity, or was there any intention like that in the act itself with respect to the subjectivity? Because if we look at the amendment which has now been brought out, what they're suggesting is that it should clarify the position with respect to the power of the adjudicatory authority in terms of Section 7 to examine the solvency and financial health of the corporate debtor, which was contrary to the decision of Honorable Supreme Court in Vidarbha. So should there be an interpretation on may, shall, or is the proposed amendment a way to dilute the impact of the Vidarbha judgment? That is a question, Justice Mukhopadhaya, for you.
I think there is no ambiguity, there is no clash between the earlier judgment and this judgment. It is only reading in between the provisions of the law.
So,
Section 7(5) is mandatory.
Correct.
It's a mandatory one. And that has been explained in innovative. Innovative paragraph 28.
So,
if you go through, if there is a default, if there is so-and-so, and if there is a debt payable, then it is to be admitted. Corporate debtor may come and say that it is not payable in the eye of law or in fact. So that judgment, if you now read it with me, paragraph 87 of the present judgment. Ordinarily, adjudicating authority would have to exercise its discretion, ordinarily, to admit an application under Section 7 of the IBC and initiate CIRP on satisfaction of the existence of a financial debt and default on the part of the corporate debtor or in payment of the debt, unless there are good reasons not to admit the petition. So this is the normal law accepted by this Vidarbha also.
Correct.
This is the law finding. The
Right.
adjudicating authority has to consider the grounds made by the corporate debtor against the admission on its merit. That is also to be heard. That is also mandate. There is no change. For example, this is the example. This is not the law laid down. Please understand. For example, is not the law laid down. It's not 141. When admission is opposed on the ground of existence of an award or a decree in favor of the corporate debtor, the awarded decretal amount exceeds the amount of the debt, the adjudicating authority would have to exercise its discretion under Section 2 to keep the admission of the application financial creditor in abeyance unless there is good reason to do so. So suppose the corporate debtor says that it is the execution stage and it will be decided at the decree, I will get the money, or order has been passed. There are many awards in which award has been passed even up to Supreme Court upheld. But money has not bin
Bin
transaction.
Yes.
So Supreme Court says, wait, because the decretal amount is more than the amount, exceeds amount of debt. Read it.
Correct.
So
Correct.
where more amount will be, person will be getting, because it has already been decreed
Yes.
and it is finality. Decreed means reach finality. So
Correct.
better to it, because
Yes.
total debt amount will be, this is the example given.
Correct.
What we would have exercised this discretion to keep the admission of the financial getter in abeyance, not that you
Yes.
dismiss.
Correct.
Unless there is a good reason not to do so. No good reason not to do means award has been passed. Section 34 is very pending.
Pending.
Decree
Correct.
has been passed. Appeal has pending. Not
Correct.
reach finality.
Correct.
So not to wait.
Hmm.
The adjudicating authority may, for example, admit the application to financial getter, notwithstanding any award or a decree. If the award, a decretal amount is incapable of realization, so where there is no chance of realization for the present, then I admit the
Right.
example is only illustrative. So first of all, this is not 141. And
Right.
second thing, it is in consonance with the law. You issue a notice. Some people say, sir, give me time for 4 months. I will settle it. All right, I keep it anyway, evidence for 4 months, because you will be giving more money. It has already been decreed. It has reached finality. It will come. But where it is a less amount, where it is incapable of realization, then you admit.
Correct.
So where is the conflict? I don't find any conflict.
So the conflict
No
is with the proposed amendment, sir. The amendment that has now been
amendment. If nobody without conflict still they want to amend, that is for the parliament.
Yeah,
we
because
can't say,
now
what
they're saying is that this may be amended to clarify that while considering the application for initiation of CIRP, the adjudicating authority is only required to be satisfied about the occurrence of default and fulfillment of procedural requirement for this purpose. So where a default is established, it is mandatory for the adjudicating authority to admit the application and initiate the CIRP. That's the amendment that sought to be brought in.
That law is already there. Mandatory requirement. It do not say it is discretionary. It is not mandatory. Directory. Supreme Court has not said it is directory.
Correct.
But I will admit today or after 1 month, the law cannot say.
Right, right. So the whole play will be about and shall.
From the very beginning, NCLAT has said and explained also, there are corporate debtor can have a 3 opportunity. One, before admission can settle it.
Correct.
Supreme Court has said.
Correct.
Another is after admission, you can settle it before the constitution of the Committee of Creditors.
Correct.
Third, you can settle it under 12A. So 3 exit point is there for corporate debtor. So before admission, if the corporate debtor wants to settle it by paying the full amount and shows that the amount is actually on the way, he will still simply give the debt.
Right.
And the amendment cannot force that no. You can't adjourn the case.
Dr. Sahoo, any comment on this? Interesting point.
No, I have a slightly different view from Honorable Justice, but in any case, this at the end of this judgment, the court writes that please don't read judgments as a statute. So judgments are judgments; they are not statute actually. If you stick to that, but again, I think the full facts were not. Sometimes I have heard that a judgment is as good as the advocates assisting the bench.
Absolutely.
In this bench, I don't see that there was a reference, at least not in the order, that reference to the notes on clauses to the bill. Section 7, subsection 1, 2, 3, 4, 5. For each of these, there's a long paragraph explaining what is the role of adjudicating authority, why default is told, why extraneous things shall not be considered, and why this is also a commercial matter, whether to start a process or not. It's a commercial matter. If the court says that no, I don't allow you to start, that means the whole good or bad consequences are on the parties. Parties have decided to start. So therefore, again, one more thing the Supreme Court told there, that it is discretionary for the adjudicating authority to admit, to not admit, and to keep it on hold. So there, I think, is stretching a little beyond that. You, as an authority, you can just keep on holding a matter and not decide. Then the system will not work.
Right.
Yes, very explicitly, government is trying to say that I had written may, possibly by mistake, inadvertence, I wrote the word may, but courts so far interpreted as a mandatory. But now that a different view has been taken, I do not want this view to continue, so I will rectify it. I think that should sort out the matter.
Again, I think one thing is to say, for example, is not a judgment. Example is not a illustration.
Yes, sir.
Illustration is not a judgment. It's not 141, not binding on any court or tribunal.
Right. Right.
Binding is up to the first two lines. Adjudicator has to consider the grounds made out by the corporator against the admission on its own merit. That is the 141. The rest is not 141. That is illustration.
Yeah, that's true. So moving forward from this topic, because this is a topic where there are views on both sides, and I personally also have a very strong view that there is no need for an amendment to be brought in with respect to this provision. I think this provision is clear, and irrespective of what is provided for in the statute, the discretion of the court with respect to certain indulgence, and especially in these kind of circumstances, as Vidarbha was, where there was an award which was already succeeded, and it was only about receipt of money at the end of the day. I think irrespective of what is provided for in the statute, the court definitely would have the power to extend their ability to be able to include such situations which are a little different from the general situations that we foresee. Now, moving forward to the cross-border insolvency, which is a discussion in different forums that I'm having, but then we really do not see there to be any progress made. In fact, till date, there is only one precedence that we see, which was also with respect to 2019 Jet Airways case, which became the first Indian company to be involved in the cross-border insolvency concerns, and in fact, the direction to conduct a joint corporate insolvency resolution process, which was passed in this case by NCLAT, which set a leading precedent, of course, for the cross-border insolvency disputes in the coming times. If we look at the UN Citral model law for cross-border insolvency of 1997, that also, in fact, in some manner provides for a wide-ranging solutions in order to resolve the cross-border insolvency issues. In fact, the model law provides for those four cornerstones with respect to access, with respect to a recognition, with respect to coordination and cooperation. But still, the development of cross-border insolvency regime is mostly still up in the air. And there aren't too many positive steps which have been taken in that regard. So, Dr. Sahoo, I wanted to ask this question to you. What are the concerns in relation to the delay in implementation of the cross-border insolvency provisions? And what are the kind of challenges that are, in fact, foreseen in such circumstances?
Yeah, I think you are asking the right question to wrong persons. Ask this question to Parliament, government, who have to make it. But I think there is an interest to do it. Probably government is looking for some right time, or maybe government is not fully convinced on the merits of this, because at least I do not see any paper or write-up or somewhere somebody saying that cross-border insolvency, if we have it, we will gain this much and we will lose this much, we will be net gainer.
Yeah.
Not a single piece of paper I have seen. We are all talking that we want cross-border because others are having it. Yeah. But how it will affect our country, that is not available anywhere. So if you open up a trades with other countries, we do calculation how much our country is going to get, how much our country is going to get. And then we take a call what is good for us and what is not good for us.
Yeah.
But I think that kind of a paper, study, research, somebody economic analysis that this much gain we will have, this much loss we will have, this much that is not available. I think in the absence of that, it is very difficult to persuade parliament or government to have a law like this.
Right. Justice Mukhopadhaya, would you also have some comment to make on this?
You see, cross-border is a 234 is very clear.
Yes, sir.
So till they agree, there will be an agreement. It's not the government cannot decide. If the government of India has no, or central government has no, one-sided power to decide it.
That's right.
It will have to negotiate with the countries.
Sure.
It will have to make agreement. So it is not in the hand of one government, but it is also hand of the corresponding government of the other country.
Okay.
Till the agreement is there, and if there is there will be an agreement also. For that also, they will have to put some terms and conditions. Our government will be putting some terms and conditions. And loss and profit is to look into what Mr. Sahoo has said.
Yeah.
Do we gain or do we lose? In cross-border insolvency, a person who has not a financial creditor here, triggering there, there may be some gain and loss because of the economic position that is to be seen by the government. Or the other government and their economic position, therefore it is for the government to decide, and therefore legislatures have left it on the government and not on anybody. 234 is central government, I hope.
Correct. Yes, sir. That's right. It is.
So they have delegated the power.
Yeah, but even after 8 years of IBC coming into picture, so I think it is now time for the government to lay down a framework in this regard, because otherwise we are going to lose out on a lot of the cross-border issues which are pending. And thankfully,
if I give you one example, Article 139 was enacted on 26th of November 1949. Article 139 is empowering the Supreme Court by an act with regard to other writs, which is there with the High Court.
Yeah.
So 26th November 1949, 139 was enacted, but no act has been enacted by the central government in empowering the Supreme Court with such power as under 139. So don't say high time, not time, high tide or low tide.
Right.
No, high time, I fully agree, it's a high time. But is there a demand for this? Demand means it's not just a
discussion.
Just a discussion, propaganda, or social media tweet something.
Correct.
It has to be sufficiently explained in a convincing manner that yes, our country is losing X rupees because of this.
Correct.
So unless you show that, like we say, there's a difference in desire and a demand in economics. If you desire to have something, that's not enough. It has to be demand. Desire has to be backed by the ability to pay, then it's a demand. So if you have to demand for cross-border insolvency, it has to be like that.
I think Jet Airways case, in fact, that way is paved way for these kind of scenarios. In case it emerges at any point of time, I'm sure we will be able to find our way through the way we did it in that case, at least. So I'm sure, we are going in the right direction, but definitely there is a study which is required and some sensitization which is required for the government also to get into it a little more seriously to be able to find a solution around it. Now, from cross-border, I would want to jump to real estate situation, because that's another issue which is a very concerning issue. Which there are too many home buyers which are associated with this situation, and they are not having a clue on what to do and how to go about it in terms of finding a solution to this. In fact, we are hand-holding some of those clients, and we also are, on the boat that they are in terms of providing solution. Now, in the case of Shelltrax developers versus Tata Housing, the application was filed under Section 60, subsection 5 of the IBC. And what was sought in that was the permission to constitute a project-based committee of creditors for the purpose of conducting reverse corporate insolvency resolution process, which was mandated by the Honorable NCLAT in the Flat Buyers versus Winter Hills case. And the second permission was to issue separate expression of interest for each project under control of the corporate debtor, and to consequently invite and place before the respective committee of creditors resolution plans for each project under the control of corporate debtor. So the NCLT Chennai bench, they said that on a thorough reading of IBC read with the regulations thereunder, it envisages that insolvency of the corporate debtor, it can be seen there is no concept of limited CIRP or CIRP for specific project anywhere. In fact, the NCLT Chennai bench was of the view that the mechanism which was adopted by NCLAT was too peculiar with respect to the facts and circumstances of that case in Winter Hills judgment, and it cannot be used as a precedent in the said scenario. Now, despite the seminal development of IBC, which we have seen via the judgment of Flat Buyers Association versus Umang Realtek, the NCLTs are yet not in favor of understanding the concept of reverse insolvency or not implementing the concept of reverse insolvency. And what is the gap or the loophole which is yet to be covered? And is there a need for an amendment to provide clarity with respect to the concept of reverse insolvency? This is a question for Justice Mukhopadhaya, because he was the author of this judgment of Flat Buyers versus Umang Realtek. Sir, because there is something which is provided for in the proposed amendment also in this regard, and therefore this question becomes relevant to talk about, sir.
First of all, with the due respect, I'll be telling one thing. The application by the RP was misconceived.
Right.
RP was not the RP of different project.
Okay.
Corporate debtor may be one, project may be at Delhi, project may be in Noida, project may be that is in UP, in Kerala, anywhere, in different states. Corporate debtor is common. Now this project-wise, there is no question of one NCLT has a power. If you say combine all, so NCLT has no power with regard to jurisdiction, with regard to the other place, a project, merely because company is here.
The registered office.
Now, if you look into the Flat Buyers Association Winter Hills, Flat Buyer in the very beginning has relied on a judgment of Pioneer Urban Land Infrastructure Limited and another. Pioneer had already laid down that how it is to proceed.
Okay.
Look into the Pioneer. Pioneer said that IBC will not prevail, but it is to go along with the RERA. Because RERA had been implemented earlier than it has come earlier than the IBC, so it is to be taken. And in the Pioneer's judgment, the difference has been shown by the Honorable Supreme Court. If you look into the definition of RERA and judgment of the Supreme Court at paragraph 21, Pioneer's judgment, it may be stated that section 220 so-and-so of this statute, RERA, were brought into force on 1st May 2016, that is prior to the Insolvency Code. And then the relevant provision set out therein, in this context, unless otherwise, adjudicating officer means adjudicating officer appointed under so-and-so. Allottee in relation to a real estate project. So RERA says allottee in respect to a real estate project, not corporate debtor. And everything permission is to be taken from the RERA. Now, RERA of UP is different than RERA of Karnataka.
Yeah.
It's different than RERA of Delhi.
Hmm.
So, this act is to be read with IBC.
Yeah.
One RP has no jurisdiction to look into the other project.
Hmm.
Because if there is a prohibition, in essence, everywhere the authority is different. The project and who has to follow all the procedure of the RERA, which is binding on the project,
Yeah.
their allotee meaning is there. So, no promoter shall advertise, market, book or sell for sale, invite this section 3 person to purchase any manner, any plot, apartment or building as the case may be, in any real estate project or part of it in any planning area without registering the real estate project with the real estate regulatory agency established under this act. So it is all separate.
Hmm.
There cannot be, why a RP had gone, I don't know. RP had been given for a project. That is how the taken into, if you look into paragraph 5 onwards of the Flat Buyers Association.
Yeah.
Now, difference has been shown. Why reverse it was said? Financial creditor secured can get the asset.
Right.
Financial creditor unsecured cannot get the asset. Here, unsecured financial creditor are to get the asset.
Hmm.
It is their flat.
Correct.
And the bank who are secured creditor are not supposed to get the flat.
Hmm.
Asset of a company cannot be taken during the insolvency resolution process. But here asset is to be transferred during the insolvency resolution process or thereafter.
Hmm.
So all these things are in the reverse direction.
Hmm.
Therefore, it was called a reverse insolvency resolution process. The process, but it does not mean that you club together. It is a project-wise. Project-wise, that is the Honorable Supreme Court has said. Now, the comparison has been made by the Honorable Supreme Court. You look into page 7980. That is the judgment where I am just showing you. This is paragraph finding in Swiss Ribbons versus Union of India on the nature of operational creditor, financial creditor vis-a-vis allottees. So a chart has been given, and in the chart, the distinction has been made by the Supreme Court. What is the difference between these allottees? Real estate allottees make payment to the corporate debtor in lieu of services rendered. That is construction of the apartment. In several cases, payments are also made on the construction link basis. All these have already been explained in Pioneer Scheme. And allottees in different real estate projects of a corporate debtor may have a different interest confined only to that particular development. So already that distinction and finding has been given by the party. So allottee in one project is a financial creditor in one project, operational creditor in one project, and the other creditors or the stakeholders in one project are different than the other project. Therefore, RP could not have moved an application of a project to club together this. So this concept is not there. Reverse is a process that has been explained. But that is not the law. That is the law already explained on the basis of pioneer judgment. That it will go to the allottee, it cannot go to the secured creditor, but asset will go. In that case, the asset should not go. These are the distinction has been made. Therefore, it was named as a reverse corporate insolvency resolution process. But that is to be followed in all the cases, not required to move before the NCLT. that you club together, you make me, I'll look into all the projects. The RP appears to have agreed to run all the projects. No, another project may not have defaulted.
Right.
Why the lakhs of allottees of other projects or thousands of allottees of other projects? Why they should suffer for no fault of them? Because some allottee of the one project has suffered, that project is abandoned or has gone for insolvency. So all projects should go for insolvency.
Mhm.
That is the reason if go through the pioneer judgment.
Mhm.
Pioneer judgment has said that RERA is to be followed.
Mm.
Now, if the RERA is to be followed, then RERA will be different in different state authority.
Right.
And different state means different project. And even in one state, there district-wise or separately, there may be separate approval of the plan.
Mhm.
Therefore, it cannot be clubbed. Don't rely on NCLT judgment because the RP was filed without application of mine and NCLT equally without application of mine said that we don't have jurisdiction, etc. They should have said you can't club together.
There is a question which has been asked on this issue itself, sir, and I would ask Dr. Sahoo also to give his views on this. That did pioneer judgment hold that RERA will prevail over IBC in real estate?
Not prevail. Go hand to hand. Judgment is there.
Yeah,
Not prevail.
It does not prevail, but only if somebody can bring up inconsistency, only on those aspects, IBC will prevail.
Mhm.
But actually, this IBC was meant for is structured with a particular structure in a view that a corporate is financed either by debt or equity.
Correct.
Equity people take very high risk, debt people take risk, but less than that equity people take.
Correct.
And the law says that if equity people have failed to deliver, the debt people, the creditors will take over the company, will decide its fate.
Correct.
But there are arrangements where business runs not on equity money, not on debt money, but on client's money,
Yeah.
like the banks, insurance companies.
Mhm.
In those cases, IBC is not suitable.
Correct.
Therefore, IBC does not apply to financial service providers.
Mhm.
Some an interim arrangement has been done to address the financial service provider issue as a stopgap arrangement, but IBC, normal IBC cannot apply to a place where money is not debt money, equity money, where money belongs to clients who have deposited money in the bank, and when they deposit, they do not take any risk actually.
Mhm.
It's like you have paid 10 rupees to buy 1 kg of potato. You had given 10 rupees to the shopkeeper. Before shopkeeper could deliver, there is some problem and you didn't get it. Therefore, we consider you as a creditor, come in the queue of creditors. So home buyers are actually clients. So the IBC structure does not fully support that kind of structure. Therefore, you need some innovation. Honorable Justice did one, and IBC discussion paper now is suggesting something like that. So you need a truncated form of IBC. Normal IBC cannot apply to a place where client money is held up who have not taken any risk of the business.
Absolutely, absolutely. And I think that is why, looking at Section 462 of the Companies Act, the present suggestions or the changes that have been, proposed, they do take into consideration that I think there are certain class or classes of corporate debtors which should, be kept out of the provisions of IBC, as you rightly said, like the financial service providers. Similarly, I think the real estate companies, if they are taken out of the purview of IBC, would be probably a better solution to this kind of a situation where, otherwise it becomes very difficult to even finalize the nitty-gritties of the issue, and there would be many more questions which would continue to arise if we keep the existing provisions as it stands today into consideration.
Or business will change their business model.
Yeah.
This problem does not arise in many developed countries because there people do not pay money to get a house after 10 years. They buy a flat ready-made, pay money, take possession.
Correct.
So the
Correct.
business model in our country may change so that it becomes IBC becomes suitable for them.
True. True. True.
So either IBC, a modified IBC has to apply to them, or they have to change the business model.
Correct. 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 One last question before we take on the questions. One is with respect to the PPIRP, because that's another talk of the town. There is a lot of discussions around it, which is applicable at the moment only for MSMEs. And we have, few isolated cases that exist as on today, which is on Loon Land Development Limited, which was before NCLT principal bench, and where the principal bench had taken into consideration the PPIRP provisions. Now, and this is a question to both of you. We'll start with you, Dr. Sahoo, and then I'll take it to Justice Mukhopadhaya as well. How do you see the effectiveness of the pre-packs in cases of MSMEs? And do you think that pre-pack shall pave the way for maximizing the value of assets, which really is the essence of IBC in case of corporate debtors, which are not MSMEs? So can we take it from MSMEs to other corporate debtors as well? So that's the question that I thought I'll ask you.
No, definitely. Pre-pack is an arrangement where we allow parties to mutually agree upon something and which will be blessed by the IBC system. In both processes, there are arrangements to have a value maximization. It's difficult to say that pre-pack will give better value, CRP will give less value, or the other way. Both are modeled on such a pattern that, and both in fact allow today Swiss challenge method also. So it is a question of convenience. Who wants to pick? Market should have choice. So law has given them the choice, either use A or B or C, depending on your suitability, but it is not that A will give better value realization than B or the other way.
Right. Just
Second, as I mentioned about the cross-border, we have to be convinced of the demand. Is there a demand for us? We have been hearing that we want this for non-MSME corporates.
Correct.
But if 2 years have passed, for MSMEs, we have only 4 cases admitted. That means either there is no demand or the design of a pre-pack is not suitable. Both are correct actually. Both are correct. There are problems with the design, problems also with the demand part. Even when the IBC came, CRP came, there was very little demand for CRP. Government had to promulgate an ordinance to direct RBI to direct banks to file applications. So market quite often does not respond to the changes. It requires some kind of persuasion or some kind of pressurization. So similarly, I don't see that there is really a demand for this. If there is a demand, then at least they would use some other pre-pack mechanism, not necessarily under IBC. But even under IBC also, they should have used it. It is not happening.
Right.
Third is, we are talking about this is structural issue. Third is MSMEs. This is today available for about 1 lakh MSMEs only.
Correct.
About 1 lakh companies or so, or 1.5 lakh, they are MSME companies. But we have 6 crore MSMEs in the country. So the real beneficiaries are there. They are the people which are the places for startups, business entrepreneurs, failures, proprietorship and partnership firms. In fact, this IBC in the long title, it says that it is for entrepreneurship. And entrepreneurship you find only at or mostly at with proprietorship firms, partnership firms, small businesses. But if you do not have that, actually you have forgotten that objective. So that actually we are thinking something different than moving away from the freedom from failure, freedom to exit. This is 6 crore business units are sitting. For them, this is not available. But we are asking that let this be available for corporate MSMEs. I would say that the demand should be for those people where the need is more. Corporates have many ways of getting things done. Fourth is pre-pack is a market innovation. It happens everywhere in the world by a market innovation. There is a standard practice, a practice number 16 of insolvency professional in UK. Under that practice, pre-pack is done. It is not under the part of the law. But here, like this kind of a demand, we want A, we want B. People wanted, we want pre-pack in the statute, then only we'll do the wonders. Actually, quite often it appears that we want something for the sake of having it, not to use it, as if pre-pack is the end in itself, not a means to some end. So in the process, what was done? Pre-pack process, which is supposed to be informal. A bigger body of law you find in IBC, then there is for CIRP. Once you put so much of law in the body of the law, if there is some problem, you can't change it. In IBC, we experimented 75% voting does not work. We brought to 66, then brought to 50, then told in classes, if the majority support one thing, we'll say 100% of the class voted. So in pre-pack, we have told 75% of shareholders, 66% of committee operators, all those things. If there are problems, you have no way except going to parliament. So actually by this, we have introduced more rigidity than what we wanted. Ideally, this should have been an informal practice, at best in the regulations, not in the statute.
Itself.
Therefore, our demand is actually sometimes, as I told, we want, even if we don't need it, we want to get it. So that approach is creating problem here.
Right. That's interesting. Dr. Mukhopadhaya, would you also want to respond to this question?
No, I think it has been clarified. Choice is on the party, and I do not think much of cases have come under this provision of law. People choose to go for the general one, and I think that is all right.
Right. And we probably also will be changing the entire model from creditor in possession to debtor in possession. Probably that would also be against the interest of what IBC was promulgated in the first place for.
Yes, what has been explained, already explained and has gone to our blood.
Correct. So there is one question that I would want to take up, which is there on the chat box before I close the session. And this is from Mr. Saurav Rajpurohit. He says, what is your take on that? In spite of the code have a time period of 330 days as per section 12. There are very rare cases where the resolution is completed within the given time. So my question is, if a statute boasts of being time bound in nature, then don't you think such extension defeats the purpose of having such a mandate? I think both of you could give your short comments on this, and then we could close.
No, it is not happening. It is not happening. I am also equally concerned, and all of us, including the government, NCLAT, committee operators, RP, everybody has a role in ensuring that it takes longer time.
Correct.
We need more discipline, we need more competency, we need well-equipped NCLT, we need more responsive RP. And there is actually our system, we are not really geared to work in a time-bound manner. So something to do with culturally, something capacity issue, and some discipline issue. And we have a tendency of saying things are getting delayed only at NCLT. That's not right, actually. It gets delayed at many places. And it's a this problem has to be seen holistically. And unless you really do this, if you are not just IBC boasts of something, but if you can't set this aspect alone right, IBC will not be used at all. Today, what happens is, I'm just giving one example in the context of NCLT, but it equally applies to every market participant. A resolution applicant submits a resolution plan, hoping that it will get approved in the next 3 months, 6 months, then it will take over the company.
Correct.
But if it remains 3 years there, and he cannot go back, and that's rightly so, that is the correct position, that once you submit a resolution plan, you can't go back, and Supreme Court has held that.
Right.
If after 3 years, when market situation has changed, you force me to take over that company. In fact, you are saying that I myself should go bankrupt. Forget about the company which I want to rescue. I will go bankrupt if I take over. And this fear that approval will not come in time and I have to take over a company which can get me bankrupt is discouraging people to submit resolution plans.
Mm.
That is why, quite a bit to my understanding, why we are getting less value. This is one of the reasons that people are not interested to take this kind of a risk. Why should I have 3 years waiting time, take the risk and I die myself?
Correct.
So
Correct.
if we do not, I gave you only NCLAT example, I have examples for IPS, everybody.
Right.
If you do not set only this aspect right, IBC will be another Sika.
This is Mukhopadhaya. Would you want to take some part of the blame as a part of the judiciary that, there are delays, and it is correct actually in some manner that there are delays?
I'll be going with the law.
Right.
Delay is related to the law. If you read it, section 12, then you find that there is only 180 days, not more than that.
Correct.
It is not 330 days. It is 180 days is a mandatory even now.
Correct.
70 days, the language is different. The NCLT do not go on that. The language of the 70 days is on the subject matter.
Yeah.
If the NCLT is satisfied on the subject matter is such, not that I have another resolution plan, I have 4 more has come. Those are not the ground. Law should be explained. If the law says that you can enlarge only on a subject matter is such, now what is subject matter is such? Subject matter I can understand that because of COVID, it cannot do. But not that I have a resolution plan, another. This is where is our fault in reading the law. Subsection 2 has not been properly read. Except the subject matter concerned, the NCLT has no jurisdiction to extend even for 70 days. There, I think NCLAT is to explain, or Supreme Court is to explain the law, or government must make it clarification, whoever may be the party, that's what is the meaning of subject matter. If I read into section 12, it's a very interesting language there. Section 12 says, time limit for completion of insolvency process, subject to subsection 2, the corporate insolvency resolution process shall be completed within a period of 180 days from the date of admission. 2, the resolution professional shall file an application to the adjudicating authority to extend the period of complete resolution process beyond so and so days if instructed by the resolution passed in so and so. 3, on receipt of the application under subsection 2, if the adjudicating authority is satisfied that subject matter of the case is such.
Yes.
What is the meaning of subject matter of the case is such? Nobody has explained that what is subject matter of the case. What is the difference in that case to grant another substance? So subject matter of the case will be different to one to another, not another resolution plan. That is not a subject matter. Not that we require more time for this purpose or that purpose. This is one part. Second thing is, IBBI has been given power to the regulatory power to take disciplinary action. But monitoring power has not been delegated to the IBBI.
Right.
According to me, IBBI should be delegated with more power to ask for explanation that why you have not completed it, submitted within 100 days. Because you are chairing the session. If the IBBI has given 75 days, then why you have gone to 90 days? Is one part. Second thing is regulator. There is no regulator for the purpose of IBC with regard to committee of creditors. This committee of creditors are playing havoc. After my retirement, I am understanding more how the RP and committee of creditors are playing one or other way, because they want an opinion on that also, how to play on it. I'm very candid and speaking straight away. Therefore, there should be a monitoring by the IBBI that why you have not followed our guideline. And while getting so, the RP should be set. This is one. Second thing that NCLT requires colloquium, which has not been held in this site, that what is their power under subsection 3 of section 12? What do they mean by subject matter of each case?
Right.
So I think section 12 will be doing that. And if that is explained by the NCLAT or the Honorable Supreme Court, or if the lawyer argues that you can't extend, there is no subject matter, then also you will be getting a judgment.
Correct.
Lawyer should also argue that you can't extend.
I think that is where we would want to end the session. There was one comment come question. I think it is related to what we are discussing. Why the financial creditors have reduced filing section 7. This is a comment by Alokji. I think the answer we have already discussed in depth. Apparently, only 4 to 6 applications are being filed as bankers feel comfortable with SARFAESI if exclusive EMG. Any thoughts on how to have confidence of financial creditors on IBC? And the following question is ED attachments devaluing the value and discouraging the resolution applicants coming forward? Both the questions have been asked by Alok Kumarji. Would you want to answer the questions? I think we have already discussed most of the points, why and what are the reasons. But if there is any take on as a final comment from your side, sir. And also, how do you see IBC faring in 2023 and onwards? What is the future looking like for practitioners like us?
Question to whom?
Either of you, sir. Both of you, rather. I would want to hear from both
Question
of you.
for you, sir. Concluding answer.
So far as IBC is concerned, what I have seen in my about 4 to 4 years of experiences in the field, there are a lot of amendments which has been made within 3 years or 4 years to ensure that the law goes in a smooth fashion. Still, the government is running on this and looking into this, how to make amendment. So for lawyers, they can address the court for coming 15 years. Law is to develop in coming 15 years. There are various nitty-gritties and small points. I think lawyer must club different law together. If IBC is not clubbed with the company law, then it can't go in a harmonious way. So because the company law has been amended, look into section 424, that the procedure of the Companies Act or the IBC will be followed. So where to follow the procedure of the IBC, where to follow procedure of the company law. So those are the things, and there are various other amendments in the company law. There are various amendments made pursuant to the Competition Act in the IBC. So I think there are various things which have to be clubbed together, argument is to be made, and small points are to be developed by the lawyers. Lawyers will not go empty hand, they will fill up their full bag, though it is the corporate debtor may lose, or the resolution applicant or the financial creditor, or the operational creditors they may lose. But I think the law is to be explained for another 10 to 15 years. It requires.
That's right. Dr. Sahoo, your final comments on the future of IBC?
Yeah, we have seen the sincerity of the government and IBBI in addressing the difficulties.
Okay.
And right now also there is a proposal to address the problems.
Yeah.
I think no law ever has taken so much time or attention of the parliament than IBC has done.
Yes.
So therefore, government will not let it anywhere lapse. There can be, when you think of a law like this, which affects the rights of so many people, in the journey, there can be some slow journey, fast journey, moving a little left, right, or sidestepping, going 3 steps up forward, coming 1 step backward. These things have happened we have seen in every other economic reforms in 90s. But trend, the path that remains clear, it will move ahead. The scope is bright.
Thank you. Thank you so much for showing us the way forward, because that really is encouraging. And you're right, because when we looked at Arbitration Act from 1996, when the new law had come, from then the law had developed through judgments, and it was only in 2015 that the government had intervened in terms of making the amendments, which was absolutely necessary. But in IBC, we have seen a different trend where the government is so proactive that the moment there is a judgment which actually interprets something which falls on the domain of a gray area, there is a clarification or an amendment which comes immediately. So definitely the law is going to take its own time to develop, and there is a lot of scope for us lawyers to interpret and be present before the court. So thank you so much, both of you, Justice Mukhopadhaya.
One thing I'll be adding.
Yeah.
IBC, I think, is the only law which has the economic justice delivery system.
Absolutely.
No other law has the economic justice delivery system better than the IBC.
Absolutely.
That's my comment.
Absolutely. And I hope that we don't go the Sikha way, because we have really lived through those times, and I would not want to revisit those times. So with that positive note, thank you so much. Thank you.
Thank you.
Thank you so much.
Okay.
Bye, sir.